Good evening. Welcome to the Thursday, May 8th, 2025 South Haven Planning Commission meeting. Call the meeting to order. And if you would, the roll call, please.
Michael Campbell,
Here.
Clark Gruber,
Here.
Larry Heinig,
Here.
Mary Hasley,
Here.
Amy Nichols,
Here.
Eddie Polk,
Here.
Bob Sherman,
Here.
Janice Varney,
Here.
Tim Stegman.
Here. Next up, item 2. Anybody wish to make a motion?
I move to approve the agenda as submitted.
Support.
It's been moved and supported. Any discussion? Seeing none, all in favor, please say aye.
Aye.
All opposed? Brings us to item 3, approval of the meeting minutes from April 10th.
I'll make a motion to approve the meeting minutes of
Sec-
Thursday, April 10th.
Second.
It's been moved and supported to approve the minutes. Any discussion?
Mr. Chairman, I would like to suggest that either for these minutes or for forthcoming minutes of future meetings, that the minutes reflect the names and the addresses and the speaking points for the people who sent correspondence to us, so that they're treated with the same, same touch that we give to the people who are talking at the hearings or for the comments period.
I don't think the emails usually include their addresses, do they, Kelly?
Sometimes, but not always.
And it could just be whenever they are included. But it would allow then the minutes to reflect who spoke, who wrote about what, and if it was a for or against kind of position, it could be recorded just as they are for the speakers during the comments period.
Any other thoughts?
Yeah, I would support it, and because it would help confirm whose correspondence was and was not recorded. When I listened to the recording comparing to my notes, I found 3 that were not recorded, although one person spoke. So I do not believe Bridget Morrissey, Miko's name was read, or Paul and Sheila Dow, if I heard things correctly. And Carollo's name I do not believe was read, although he spoke.
You're talking last meeting,
Correct.
because I have those names for this meeting.
Maybe they came in after. I just had
I
them
have
all.
an April 14th communication date,
Okay.
which I'll be reading there shortly.
Okay.
And my comment is not to necessarily have to amend the current minutes, but rather on a going forward basis, consider that as being a way to document
Well,
the names and so forth of people who wrote in.
I hear what you're saying. Then I would have to add that to my list as well. We all get those letters, correct?
No.
And,
The emails.
The emails.
yeah,
The emails,
Yeah. But I think in the past few meetings, hasn't there been a log? Hasn't Commissioner Gruber been saying?
I had him read one since it
Yeah.
was so long and it was gonna be a big meeting,
Ah,
yeah, that I provided to him. So,
just a suggestion for consideration.
well, anybody else? I'm happy with the way we're doing it now, but if anybody wants to change it,
Well, if we did that, I think, what about following council? Would council need to do that as well? That just seems like a lot. I mean, we read them, they're part of the record, but then to put in their email addresses and addresses might be kind of tough.
Well, and it wouldn't be the email address, that would be privileged, so we wouldn't count that anyway. Again, it's just simply that it would document what you say is read into the record. I mean, the actual emails we get do not become part of the minutes or the record that
And
is
I
available
think-
to the public.
It's not a bad suggestion, but it sounds like we do more than any other board or commission or council with regards to providing communications.
Well, with the purpose of the planning commission, it may be something that we might want to get legal counsel advice on, especially when there's a public hearing.
So I totally agree with Clark. Like, we do above and beyond what anyone else does. And of course, council has public hearings and does all of that. So I'm assuming that somewhere, legal counsel has weighed in and we don't need to spend the money to call them and say, here, weigh in on this. I think it's a great idea. I think the enforcement is a problem. So if I can say to you, Mike, every time you email me, I want your address in there, and you email me once, and then you're like, she's got it after that. What do we do? Come back and we don't read your suggestion because you didn't bother to put your address in there? Right.
Well, again, I don't think the address isn't the issue because you're actually not required by the Open Meetings Act to even give your name, let alone your address. So we ask that, and most people, out of courtesy, provide that. All I'm saying is if the address is there, like we do for the people who speak at the comments period, we would include it. If they don't provide an address, we have their name. We're not going to put their email in because that's confidential and would otherwise not be provided. And so it would be simply what they spoke about in their letter, similar to how Samantha summarizes the speakers at the meeting itself. Again, just a suggestion to consider.
It's not confidential. And this is off topic, so this is what we're gonna do with this one, is we're gonna put that up for a discussion item next meeting. Okay? Because I think what's driving this is the thought that we missed some comments that were received after our last meeting rather than before. Okay, there's been a first and a second. Any further discussion? Seeing none, all in favor say aye.
Aye.
Opposed? Motion carries. Next up is public comment. Citizens in the audience may address the planning commission regarding items on the agenda for which there is no scheduled public hearing. And tonight, item 5A and 6 are public hearing.
No,
6
6
is
is
not.
setting the public
Setting
hearing.
the public hearing. Okay. So mainly item 6, master plan update. Anybody in the audience? Seeing only one, I think, coming to the podium. You're fine, okay. That brings us to our comment log. We have Bridget and James Miko, opposition to 241 Oak Street rezoning. Paul and Sheila Dow, opposition to 241 Oak Street rezoning. And Jan Lexich? Lesich?
Lexich.
Okay. Support for 241 Oak rezoning. Unfinished business, we have none. New business, item 5, temporary sign zoning text amendments, and we'll set a public hearing. First, Kelly, if you'll introduce this one.
Sure, thank you. This evening, the agenda packet contains updated non-permanent sign regulations. The staff report considers the proposed amendments against the text amendment factors that are actually in the city's zoning ordinance. And there is a potential approval resolution for your consideration. As a reminder, the proposed amendments would modify the definition of non-permanent sign, add a definition for permanent sign, and they would regulate non-permanent signs by district rather than by use on the lot, as well as establish a cap on the total square footage of non-permanent signage allowed on the lot with limits on individual signs rather than with a hard cap on the total number of non-permanent signs allowed on a lot. So that's just a brief summary. And this evening, we do need to hold a public hearing on this topic.
All right, prior to doing that, does anybody have any questions for staff regarding what is proposed?
I should also say that we have Nathan Inks here from the city attorney's office to answer any questions that you may have as well.
Okay. Any questions? And we'll go right around. Questions?
We can discuss after the hearing as well, correct?
Yes. This is just
None for now.
any informational prior to us going into actual amendments or motions, right?
Nothing for now.
Information gathering.
No, nothing.
No.
Okay, entertain a motion, open a public hearing.
Move to open the public hearing.
Support.
It's been moved and open, to open a public hearing. Any discussion? Seeing none, all in favor, please say aye.
Aye.
Opposed? Public hearing is open. Do you wish to speak? Okay. You know the rules, but I'll remind you, state your name, address, and you have 5 minutes.
Lisa Croupiers, 561 Indiana. Even though there is no one here tonight besides myself, I do speak on behalf of several residents about various topics regarding the temporary sign ordinances and guidelines. I wondered if past communications were going to be included as part of what was mentioned tonight, because I have written several times about various sign issues. The illuminated signs, campaign signs, and the STR signs. So I thought of resurrecting those emails and resending them, but I did not do that because I wasn't sure if they would be part of the public, or part of the record for tonight. So as far as the non-permanent signs, or permanent signs, however you want to call them, I would consider these the campaign signs that I've spoken of in the past, and then the STR advertisement signs that are in the neighborhoods. The campaign signs, I understand the restriction. It's, instead of having the number cap, it's the square footage now, which is a bit more confusing, but fairly easy to figure out. And as, I don't know if I should say this or not, but many of us have figured out a workaround so we can have just the 24 square feet, of sign coverage in our yards. And then we have determined other ways to continue to express our First Amendment rights regarding elections and actions of elections. So that is rather a moot point now, irrelevant. However, the short-term rental signs that are displayed in the neighborhoods, as we know, or maybe you don't know, but the Jaqua and Shores have been very accommodating of display of these STR signs in the neighborhood for their properties that they are responsible for. And they, because of neighbors requesting them to do so, they put the signs out at the beginning of the tourism season and then remove them at the end of the season, so that those of us that are here year-round do not have to look at those, it's visual pollution. And not to mention blowing around in the winter, those smaller signs that they use. However, there is, Beach Walk is one company that does not, even though they consider their signs non-permanent, I am told, because they wiggle in the ground, they do, I've never spoken with them. Just by what we've observed, those signs are not removed at any time. And by that display, 365 days a year, I would call that a permanent sign. When they are posted full-time, that is a permanent sign, whether it can be wiggled in the ground or not. So I'm not sure how There was no, thank you, there was no reference in the wordage, the words of the verbiage of the ordinance, the draft copy referring to STR signs, but I really hope this can be resolved. There are some options I know that our, people have mentioned, and I know those, some of those things will come up tonight from the individuals that I've spoken with. But I do contend that if a sign is displayed year-round in a spot, in the same spot, it is considered a permanent sign. And I don't know how you would consider that differently. Thank you.
Anyone else? Going once, twice, three times. Entertain a motion to close.
Mr. Chairman, I move we close the public hearing.
Support.
It's been moved and supported to close the public hearing. Any discussion? Seeing none, all in favor say aye.
Aye.
All opposed, motion carries. Is there a motion to adopt and recommend?
I would make a motion to adopt resolution number 2025-02, which recommends city council's adoption of the ordinance to amend sections 2201.02, 2201.07, and 2201.08 of the zoning ordinance.
Support.
It's been moved and supported. Any further discussion?
I'll offer some discussion,
Okay.
and with respect to Eddie, I think this is the case. I recall being told that when you define a term, it's bad practice to use the word that you're trying to define as part of the definition. But we do exactly that in this language. A non-permanent sign is a sign not permanently affixed to the ground or building. And I'm going to defer to all attorneys present. I think the word affixed, cornell.law.edu and other sources I found online, affixed implies permanency. It doesn't allow for non-permanent. So in my opinion, the use of the word affixed is not appropriate. To use permanently as it's used in here is not appropriate. I frankly don't think that the definition of non-permanent sign and permanent sign is as clear as it ought to be. And to say that it's easily removed, well, what's easily removed by one person may not be easily removed at all by another person. So I think there's so much vagueness there that it's just begging for confrontation and challenge and unpleasantness. So I would suggest that these definitions are much less in terms of clarity than we need.
Are there more examples or primarily the one?
Those two, yes, yes, that's it. That's all I had on
The
that
two
topic.
that are in bold?
Yes, exactly.
Would you like to address that?
Yeah, I can address. So I guess I'll start with affixed. Merriam-Webster's dictionary defines affixed as to attach physically. So I don't think that the word affixed necessarily carries with it any implication of permanency. To the extent that there is a desire to define permanent sign and non-permanent sign differently, I think that's something that the commission can do. My office has offered some alternative language. So if any of those alternatives are desirable to the commission, that's something that can be discussed. In terms of should the definition of non-permanent and permanent sign use the word permanently, I don't see an issue with that because permanent is being used as an adjective in the definition and being used as an adverb or being used as an adjective in the term and an adverb in the definition itself. So,
Is the adverb needed?
well, the adverb is needed, at least based on my understanding of the word affixed. So a permanent sign is one that is affixed permanently. You're not using quite the same word because one is being used as an adjective, one's being used as an adverb. So the adjective is describing what type of sign it is, and it's that type of sign because of how it's affixed, meaning the adverb. So,
If the adverb was removed, would it greatly affect the definition?
if permanently was removed, yes, because then a permanent sign would just be any sign attached to a ground or building.
That is incapable being easily moved.
Oh, I see what you're saying now.
But unless you had and as opposed to or.
Yeah, at that point, you would have to define it as any sign affixed to the ground or a building that is incapable of being easily moved from place to place.
Or incapable of being moved. I don't even think you need easily.
I would be hesitant to do that because, I mean, for example, if you have a large, heavy sign in a drive-through, you could move that with a crane or some sort of construction equipment. I don't think that's the intent.
Which goes to the fact that nothing is permanent. Which is why I agree with Commissioner Sherman that these definitions are not clear, and certainly from a legal standpoint, sometimes you want things vague. But I think in this case, you don't. Therefore, what I would have liked to have seen would be not to delineate rules based on permanent versus non-permanent signs, but rather signs that have a commercial message versus a non-commercial message. It's a subject matter that I think you can have separate standards for. And we know that commercial speech does not have as high a standing under the First Amendment as non-commercial speech. And so you could potentially have your rules based on those two. And if commercial speech is being done in a residential neighborhood, then you could have a slightly different standard for how that is expressed, whether it's, on a sign in a ground or if it's smaller or bigger. So I agree that I do not believe that this is necessarily helping us beyond what we already had.
Just to clarify, the ordinance already does distinguish between a commercial message and a non-commercial message. Both of those definitions are in the current ordinance. We haven't proposed any changes to those definitions. To the extent that there is a desire to regulate commercial speech and non-commercial speech differently, that is something that the commission could consider, but there are still standards that have to be adhered to for that. The Supreme Court has provided less protection for commercial speech, but it still does protect commercial speech. I guess returning to permanent and non-permanent sign, perhaps one of the better ways to think of these definitions would be portable and non-portable.
Oh.
And that's something that could easily be changed is if calling a portable sign a temporary sign is creating some confusion, rather than using those definitions, that we could just change it so that it's a portable and non-portable sign. And then I think you get at more of the, whether or not they're capable of being easily moved would be then a portable sign.
Chairman? Yeah, the portable sign, temporary sign, did pique my interest, but then it talked about without the use of a shovel or other tool, and I just saw that as a whole to make it vague. So I did a little bit of searching, and St. Joseph, Michigan talks about a permanent sign having a permanent location. So although the name is in the definition, it's identifying that it's a specific location, which I think is helpful. And the temporary sign talks about a non-permanent basis for a limited period of time, which I also found helpful. But I still went further, and Warren, Michigan talks about a temporary sign, and what I really liked about that was the inclusion of light temporary material. So the heavier signs like we see for some of the short-term rentals, I don't think reasonable minds should differ that those would not be light temporary material. Bob, as you aptly point out, it depends on the size of the person, whether it's easily moved or not, and hopefully you would be able to move much more than I would be able to move. But I think, that type of clarification of the type of sign for temporary adds some clarity with regard to its durability, which would then go to its limited time for display or being there permanently. I did like the idea of a permanent location. One thing I had thought about by looking through these was that removal of the sign should, if it's temporary, should not cause any change in the topography of the land. So, the little metal sticks that you have with the signs, yard signs, like the rummage sales, garage sales, those go in and come out, you don't even know they're there. But the larger signs that have like a 3 or 4 inch diameter wooden hole, first of all, I think you would need a hole digger to get them in. And pulling them out, you're definitely going to be leaving a depression because those are going in deep and they're wide. So I think that would help avoid some of the vagueness and give more predictability, consistent predictability of what would or would not be temporary versus permanent.
Mr. Chair, do you want me to address some of those comments, or?
If you wish.
Okay. So I guess starting with, whether the definition should include something about the material of the sign. If there's a desire to add to the definition of either, if we go with portable or non-permanent, something about the durability, I think that you're probably going to want to then also revisit permanent signs. For example, if you exclude wooden signs from the definition of non-permanent signs and you make those permanent signs in the residential districts for residences, you don't allow any sort of yard signs. All that you allow in the residential districts for residences are wall signs. So if you had somebody who's selling their house and was putting up one of the traditional wooden real estate signs, that would no longer be allowed.
So I meant to say excluding for sale, home for sale signs, because we know that those are frequently with a larger holder.
And that would
And
be
temporary.
content-based regulation.
I was just gonna say, aren't we back to this again? If we're gonna target the ones that we know that are short-term rentals, we're still content basing, even though we're not saying it out loud, we're still doing it.
Well,
No, it's the structure of the sign. It just,
Besides Beach Walk, why did we open up the temporary sign ordinance?
my understanding is it was not clear what a non-permanent sign was, and permanent sign was not defined.
But other than because of Beach Walk, isn't that the main reason why we're here?
Also, the disparity or perceived disparity between the commercial and non-commercial regulations.
Exactly.
So The STR
No,
businesses?
businesses
Also, for
along,
businesses,
Okay.
staff has received complaints from business owners who felt penalized by only being permitted one sign, one non-permanent sign to be displayed on
It
their
would-
lot,
they had the time period, they could do it, what, like 30 days?
30 days at a
And then they
time.
had to have X amount of time off or something like that.
And that is very difficult from an enforcement standpoint.
Right, so those are the,
Anybody else? Larry?
Yeah, I'm sitting here listening to this permanent being used in the definition and the name, and easily portable, and all those terms that have been thrown out here in the last few minutes, and I don't see anything any better than what's right in front of us right now. They all raise questions if you try to dig down deep enough and look for a question to raise. I think we've got something now that's workable. Of course, somebody's going to raise a question. They always do. But I think this is as good as anything that's been suggested.
Okay. Janice?
My only question is,
Janice,
With-
microphone.
oh, sorry. My question has to do with business signs in residential neighborhoods. How long can a business sign be up in a residential neighborhood?
Under the current ordinance or the proposed?
The proposed.
The proposed would not regulate, would not specify a time period. We would be eliminating the time period that is in the current zoning ordinance.
Okay, that's business and residential.
Correct.
Right, okay. Because that's where I see with the putting business signs, like those folks who are renting their homes and they live there, but they're renting them at various times. But those who would have a business there who don't live there year-round or any time, it's purely business, those signs seem to be the ones that are up the most often and the most substantial. So I don't know if we can regulate that business sign piece to accommodate that.
So I guess if I could ask a clarifying question. When you refer to a business sign, are you referring to a sign on a property that's being used for a business, or are you referring to a sign that advertises the business? Because even under the ordinance as it currently is, and correct me if I'm wrong, Kelly, we don't necessarily regulate business signs as in signs advertising the business. Under section 2201.082, it's based on the lot, so it's based on the use. I mean, you can have a business that has a non-commercial sign. So I think it's important to distinguish between the speech and the speaker. So I just want to make sure I'm understanding your question correctly. Are you referring to signs where the property owner is a business, or are you referring to commercial signs that are advertising a business?
Okay, no, I'm referring to, if we go into a residential area and one of the short-term rentals is a business because the owner of that building doesn't live there, it is there just to do short-term rentals. And although it's owned by an individual, but that individual doesn't live there, but keeps renting it out, and therefore is a business, that's where my thinking is coming from. I guess I'm not very clear, because you still look puzzled.
Yeah, I guess if you could just restate your question again for me.
Okay. So, I think that short-term rentals where a corporation owns the house, say, in a residential neighborhood, and it is not being used by the owners at all, and that's considered a business rather than, say, with my house, maybe I'd rent it, and I don't, but if I did, rent it out for the summer, but it is my permanent residence, And so when I come back, it's not, considered a business anymore because I'm living there. I'm looking at the larger conglomerates who buy up rent houses and rent them as businesses. And mine wouldn't be considered necessarily a business because I'm going to come home, I'm going to take the sign down, maybe put it up again in the summer. But those that have it there permanently all year round, and they are a business, I was just wondering if that's legitimate to have that business sign up there 12 months a year.
So, again, there's a distinction between the speaker and the speech. And even a short-term rental or any other business in a residential district could have some sort of non-commercial speech on their property. And the difficulty becomes if you start distinguishing between different types of speech, even between commercial and non-commercial, if you don't have a valid justification for that, that opens up the city to potential liability. So I think it's important to start from the perspective of what are the governmental interests that you are trying to further with the regulation. The courts have recognized aesthetics and traffic safety as governmental interests that can support some types of regulation on speech. But aesthetics and traffic safety concerns are largely going to be the same regardless of what the content on the sign is or regardless of whether it's commercial speech or non-commercial speech. For example, if you have a yard that is cluttered with signs, that could be distracting to drivers, but it will be just as distracting to drivers whether the text on the speech relates to a commercial use or whether it just says, I love South Haven all over their yard. So it's difficult to regulate based on the type of speech and even based on the use on the property. And that's why our suggestion was to go from regulations based on the use on the lot to regulations based on the district. Because what you're trying to promote is a cohesive district. So if you have a residential district, you want the character of that district to be similar regardless of whether the properties in the district are commercial properties or residential properties.
Okay,
Anyone else?
I understand.
Mr. President, are we done with the discussion on the permanent sign and the non-permanent sign? Is that still open yet?
Still open.
Still open? I'd like to give
Go.
okay.
Yep, go.
I'd like to give my thoughts on the definition for, starting with the non-permanent sign. Larry, reflecting on your remarks, I do agree, I think that what's written here would work for us. However, I think that it's a little too wordy. I think it can be spoken more directly, which doesn't leave room for misinterpretation or question. And just to frame that, if I were given the task of writing a definition for non-permanent sign, I would go directly to something like where it starts with examples of non-permanent signs. I would go directly to exactly describing what it represents, what a non-permanent sign is, and I would drop all that other previous verbiage, because it just inflates the definition even more so with useless, ineffective words that leave open for discussion. If I were to write the example, I'd say examples of non-permanent signs include, but not limited to, yard signs, metal stakes, banners, etc., to the rest of that, and I would eliminate the rest of that verbiage.
So your
If I were to-
let me understand, your definition would be simply a list of examples?
Yes, sir.
Okay.
All the other wordings that's previous to that, it really has no effect, in my opinion. If we went to write and redefine permanent signs, where it says any sign permanently affixed to the ground or building that's incapable, I would, incapable is subjective. as far as I'm concerned. I would say was not intended, or was not, maybe intended or not designed to be easily moved from place to place. I just wouldn't use wording that could be challenged and go directly to the point, to the action, as far as the definition, if that makes sense.
Mr. Chair, if I can address that.
Sure.
So, I mean, I think it's important to keep in mind, too, anything can be challenged.
Yeah. That is true.
That's what attorneys get paid for. So I don't want to give the impression that, you know, that any sort of definition out there would be completely immune from challenge.
I agree.
And even with just providing a list of examples, there's always going to be some sort of discretion that zoning administrator and staff are going to have. You cannot list every sort of sign.
I agree.
So there's always going to be some discretion that staff are going to have. But if you want to eliminate the description of non-permanent signs and simply give examples, with the understanding then that the zoning administration staff would have to determine whether any signs that aren't specifically
Mentioned.
included or excluded in that list, whether they fall under non-permanent or permanent, that would be an option as well.
Okay. Unless anybody else has anything, right now, there is a active motion on the floor. We can amend it. If you think it's good enough, it could pass. Or if you think it's not good enough, we can have the motion withdrawn and give specific instruction to staff for various rewrites.
Well, I kind of agree with Larry. I think what's here is, you know, is a great start. We will never, ever be able to predict every single thing that's going to happen. If we did that, we would be here for the next 6 months, hence the short-term rental, you know, debacle we just literally lived through. I think we give this, it starts somewhere, it's written just fine, it does not. What I've been all very, very worried about is that we are singling out the short-term rental signs. Now, and I don't want to do that. This is pretty middle of the road, this just kind of covers everything, and it doesn't do that. I'm also would like to make the comment that if I have a sign in my yard that I remove and it has holes in the ground that are big, that is my problem. Please don't come step in my yard and trespass and fall in my holes, right? So I hear that complaint a lot, like these big holes in everybody's yard. Well, stay out of my front yard. You wouldn't have that problem. Those are my 2 comments.
Okay.
Sure.
Yes?
So back to the non-permanent, I did have a separate question. So in the examples, it lists feather signs, but in section 2201.05 prohibited signs, it includes feather signs. So we have some disparity, and I appreciate the fact that there's the repealer, but that's fairly broad. It doesn't really give notice as to what is specifically being repealed. So if we're going to include feather signs in non-permanent, I would recommend that we amend 2201.05, 1 to strike the feather signs and reword,
So just to clarify.
or strike it from the non-permanent list.
So feather signs under the proposed definition are a type of non-permanent sign, but they are still prohibited under the ordinance. They are a type of non-permanent sign that is prohibited. If you look up on page 14 of the packet, the current definition of feather sign is a freestanding temporary sign typically constructed of a shaft, and then it continues on. The proposal would remove the word temporary and replace that with non-permanent so that it's consistent. So I guess I'm not quite understanding how there's a disparity. A feather sign is a type of non-permanent sign that is prohibited under your zoning ordinance.
That sounds good.
But it talks about allowance for residential districts, and it says non-permanent signs. And if it's an example of a non-permanent sign, then there seems to be a disparity that it would be allowed. I would suggest striking it from the definition because of the use of non-permanent sign as being allowed, so that we're not including in the example a sign that's prohibited.
I mean, if there's a desire to strike feather signs from the definition of non-permanent, you could do that, but the zoning ordinance would still define a feather sign as a type of non-permanent sign.
But see, I don't see that as a discrepancy, whereas having it within the definition and then using that definition for allowing signs, I see that as a point of confusion.
All right, just to clarify, that there are a lot of signs that would fall under the potential definition of non-permanent that would still be prohibited if they don't meet the other requirements of your zoning ordinance. So
Correct, but they're not specifically listed.
Maybe it was just me.
right. I mean, I guess I
Yeah,
would leave that to the discretion.
I don't
of
think
the
it's bad
planning
because we're
commission.
telling them, this is an example of one and you can't have it. So, I mean, if someone were to take it out, we might as well take it out of the graphic as well. On page, what is that,
What, for feather signs?
13?
Yeah,
Yeah.
13.
13.
Where are they allowed?
They're not, they're prohibited.
These are just
Specifically.
examples.
All right, so,
But they are often used, they are often attempted to be placed, and they are prohibited.
well, I'm gonna give you examples. So the steelheaders, when they have the fishing tournament, they have feather signs that show where the participants are to pick up coolers, drop off tournament participants, and where the boats are to dock at, because they put them on the pilings at the Southside Marina. So by this ordinance, that's no longer allowed.
If they receive express approval of their signage from the city council when they apply for their event, then I see that as different because it's temporary. And the city council can make that decision. But otherwise, the feather signs are not permitted.
I think we're
Mr. Chair, if I
becoming a
can-
public HOA.
If I can just clarify that, that is not a new change to the ordinance. The current ordinance prohibits feather signs, so that is not a change to the proposed, from what we
I thought it was
proposed.
allowed.
I mean, obviously, if the commission wishes to revisit that, they can. I just want to clarify that that was not one of the changes that we proposed as this set of amendments.
Right. And it's just, in the current ordinance, there are not examples of non-permanent signs.
Correct.
The examples of permanent signs entered in through this amendment, and that's why I believe inclusion of feather signs in the definition of non-permanent sign that is then generically used can cause confusion. So I would move to strike feather signs from the definition of non-permanent. Do I have a second?
Is there support?
Yeah, I'll support.
Okay, is there discussion?
Mr. Chairman, I think having it there and defining it, since it is something that people frequently request, is a good idea. Defining it so everybody understands what it is, and then a statement that it's prohibited makes it very clear.
But I think we have isn't there a definition for feather? And the amendment, as I understood it, was simply to take it out of the example of a non-permanent sign. But the feather sign is still defined, and then it's prohibited.
Well, this is a further definition, is in my view.
Feather sign is defined on page 14 of the agenda packet if you want to refer to it.
Anyone else? There's been a motion and a second. If there's no further discussion, Samantha, if you do a roll.
Campbell,
Yes.
Gruber,
No.
Heinig,
No.
Hasley,
Yes.
Nichols,
No.
Polk,
No.
Sherman,
No.
Varney,
No.
Stegman.
No.
Motion fails.
Okay.
I would like to next make an amendment to permanent sign, and I'm trying to figure out where to put it. I would insert after building and before or, intended to, I'm looking to see, intended to be displayed year-round, 365, 24/7. And that would occur between building and the or.
Mary, can you read that again, please?
Intended to be displayed year-round.
Okay, now you gotta do it in a motion form.
No, I did, I said I would move to insert after building and before for, before or, intended to be displayed year-round.
Okay. There's support? Once, twice, 3 times. Motion dies for lack of support. Any other motions?
I do have discussion on 2201.08. We hadn't got, I just was sticking with the permanent, non-permanent. I would prefer that the residential include all residential districts, so RM1 would move from other districts to RM1. I'm sorry, would move to residential districts. And allowance for certain residential districts. I would insert RM1 after R2 and before the and, that's before MHC districts. Because they are all residential. RM1 is residential. Definition is residential.
And I would concur from the standpoint, I believe, and this is where I was questioning, if we have an RM1, and I don't own any property there, let's say a Central Lofts, and there's 55 residents, and 7 of them all want to sell their property from 7 different realtors. I mean, I do think they're more of a residential than a business, and I think they should be afforded more that residential leeway.
Is there a motion?
And it also has the smaller area of the sign. Oh, yeah, so I would move to insert RM1 after R2 comma and before the and MHC.
And delete.
And delete RM1 from 2201.08 to after the and before CBD. It would be delete RM1 comma and insert RM1 comma in the designated places.
Support.
It's been moved and supported. Now is there some discussion?
I do have an additional question. Would that work then, let's say there are 8 people who want to sell property, and each one has a 6-foot sign, would we allow Central Lofts to put 8 for sale signs on that property if we adopt this?
8 signs at 6 feet.
Well, I mean,
6
they're
times 8
2
is-
foot by 3 foot, I think is
Right,
a
okay.
standard
So
for
six-
sale sign.
6 times 8 is 48, which
Correct.
exceeds 24 square feet. So I would say no.
No. That kind of prohibits, I mean, and it wouldn't work otherwise, it would be 32 in the other. So I'm not sure how, just a question that I have when we have a property and they're 10 in one unit, you know, although a different HOA, I think it's all one RM1 zone, right? Or do we allow each owner within the RM1 to put those signs in? And I'll wait for council.
It would be per lot, not per owner. And I guess just to kind of clarify one of the points that you had made, when you said that it would allow more leeway by moving RM1 into subsection 1, it's actually the opposite.
The opposite.
I was gonna say, it's
The
bad.
reason,
Smaller
fr-
foot.
and this is a complete policy decision, so, I mean, I'm only explaining why we did it, but this is not, there's no strictly legal reason that we did it. It was because we felt that the uses that you typically see in RM1 are more intense uses that would typically have larger signs. We put it in with those other commercial uses so that you could have the allowance for the larger signs. If you move it with the residential, you would have to have smaller signs. Each individual sign couldn't exceed 6 feet, and you'd be capped at 24 square feet instead of 32 square feet. One other brief comment, if I could suggest one other change to this motion would be, I think you also want to then strike the word certain from allowance for certain residential lots. If you move RM1 up to subsection 1, it would just be allowance for residential lots entirely. The only reason that certain was included in there is because we moved RM1 down to subsection 2.
I'm in agreement. We have to keep RM1 in number 2, subsection 2, because it at least gives a little more leeway. So if there are more than 2 people that want to put up signs, then they can. If we put it back in number 1, that's it. You get 1 sign, you're done, depending on the size of it. It does give a little more leeway for the exponentially increasing number of owners.
My concern is the maximum of 32 square feet for 1 sign in the RM district. And looking at different zoning ordinances for signs, I saw some that set the number of signs per linear feet in the front yard, had them set back proportionate to the height. Those I thought would be more complicated. But that's my concern is, RM1 is residential in nature, and I'm just very concerned with the 32 square foot maximum for 1 sign. That's very commercial-like.
It's not just for 1 sign, though. The combined area for all signs on the lot shall not exceed 32 feet.
But it means 1 sign could be 32.
Well, the first one could, and then you've got to figure it out, yeah. But it does allow for more than 1 sign.
It does, as long as the first sign up is not the full area.
Mr. Chair, if I can clarify, because I think I understand Commissioner Hosley's point, is in subsection 1, individual signs are limited to 6 square feet. In subsection 2, there is no per sign cap. It's just your total square footage. So in subsection 1, you can have multiple signs up to 6 square feet each, 24 total. In subsection 2, you could have a sign that's as large as 32 square feet, or you could have a bunch of smaller signs. And I guess, just a suggestion, if there's a desire to remove RM1 from subsection 2, but you don't think it fits in subsection 1, if RM1 is a unique category, you can always add it as a third category and come up with a different limit. Again, these are policy decisions for the commission to make. There's not necessarily a right or wrong or even best practice aspect from a legal standpoint. So I would defer to Ms. Getman to set in terms of best practices and, in her opinion, from a planning and zoning standpoint.
All right, any other discussion?
Well, this still brings up the, what rights do we allow 55 owners? And that particular, we've got other RM1s with multiple owners. I think typically you don't see that number of signs. I would hope not. That's a lot of signs. But you do from time to time, if someone were to have an RM1 project, they may put up one initial sale sign introducing something coming or something for sale. I don't know what we would want to do for that. And some properties are situated where it's the complaints that would be generated if someone had a sign on 3 different streets because that RM1 property was on 3 different streets. Some people might not even know that there's an issue.
Yeah, and I mean, the way this was originally written was for residential and non-residential, and that's why you have the larger square footage for the commercial type district versus the residential district.
Wouldn't it be easier to lower the 32 feet to something smaller and then then leave it as, the combined area for all the signs should not exceed 32 feet, just like above. It goes 6 square feet and then 24. Wouldn't it be easier to leave it in there and just change that 32 feet?
I would be concerned about the impact on the commercial.
On the commercial
Some
businesses.
commercials have them.
Yes, that would
Like,
impact
what's
all the commercial
Barrios?
districts.
What's the sign for Barrio sign? Do you know?
Well, does not impact their permanent signs.
No, I'm just trying to get a perspective,
Of the size of that sign, I couldn't tell you off the top of my head.
because it was relatively newly.
That was a refacement.
Yeah,
Well, we
but
could do little
existing,
math things like
so-
4 feet by 8 feet.
4 by 8 is 32 square feet, and it's
2
not as large
4
as
by
you might
4 signs, all kinds of fun
Yeah, like,
stuff.
There's some, yeah.
All right, there is a motion on the floor. Is there any further relevant discussion?
A relevant discussion may be, what about section number 3, and it's just the RM1?
Yeah, adding a new section.
Yeah, and a new section, and it may be written almost exactly the way the certain
The
residential lots
section
are,
one
because
is-
it is a residential, but then somehow the ability to more signs per owner
Unit?
within RM1, I don't know
Yeah, per
how to do
unit?
that.
Is that, it'd be limited 1 sign per unit? I don't know. Is
Yeah, one sign per unit. Then you don't have 2 signs.
Not to exceed X amount of feet.
Yeah, basically that basic sign, which is only, 6 foot,
6 square feet.
6 square feet? Or what are your thoughts, Kelly?
I
A lot of
think
things are going on.
I think that would be something that we would want to spend some time researching, because I think there could be some far-reaching implications that we might not consider in the short time that we're here tonight. So if that's a change that you all desire, we would want to do a little bit of research and bring it back.
And I don't know if I want to throw this because of that. I think putting the RM1 into the residential, because it's residential nature, and going with a sign ordinance, and then later amending just one section seems better than, once again, waiting and waiting and waiting. Progress over perfection, I've heard that before.
Just a little bit.
Yeah. I'm good with moving it and also fixing it down the road. I don't think it's going to present a lot of problems.
Yeah. And so then, in light of your comment, and I actually have it stricken in my draft, I would move to strike certain from allowance for
Hold
certain.
on. We have a motion on the floor.
But
That's already
Do
been
we want to
made
do
and
them
supported.
separately?
Amend the amendment?
You want to amend the amendment?
That's what I was going to do, because they're related.
So you're withdrawing your motion.
No, I would amend, so it's been seconded, and then I would amend the motion to include striking certain. So we would be moving RM1 from 2 to 1, striking it from 2. That was the original motion.
I could amend her motion, it might be cleaner.
I just want to make sure everybody sitting here understands the language being proposed.
I suggest we consider the motion as it was made and seconded without an amendment, and then if there's a second motion that's somehow related, I think it
Yes,
would be
that's much
less
cleaner.
confusing.
Much cleaner.
Good plan.
Yep, that's fine.
Okay. Because you're also assuming it'll pass.
Correct,
Doesn't pass, we don't need the Second Amendment.
Right.
correct.
Yeah, good.
Then you can make a
point.
whole new one, right, with your amendment. So, okay, I agree, that's cleaner.
So can we have the motion read so we all know what we're voting on?
So it would be.
Samantha, she's our official.
Interpreter.
To insert
Oh,
sorry. To insert RM1 after R2, comma, and before MHC in subsection 1 of 2201.08, and delete RM1 from subsection 2 of 2201.08.
Thank you.
Including the comma.
Okay, everybody's clear? Samantha will do roll.
Gruber,
Yes.
Heinig,
Yes.
Hasley,
Yes.
Nichols,
No.
Polk,
Yes.
Sherman,
No,
Varney,
Yes.
Campbell,
Yes.
Stegman.
No,
Motion carries.
passes. Okay,
Now I would move to strike certain from 2201.08 after allowance 4 and before residential districts.
Second.
what page in the packet, please?
It's,
Still
it's
page
right up
17?
there. It's,
17?
Oh, duh.
The paragraph used to be certain because we had some of them removed now.
Yeah, so the certain is redundant.
Yeah.
is the
Yep.
point.
And I second.
any further discussion or clarification on why you wanted to do this?
that, I had it stricken and the attorney had also recommended it, so.
Yes. Okay. Same thing, roll call.
Heinig,
Yes.
Hasley,
Yes,
Nichols,
Yes.
Polk,
Yes.
Sherman,
Yes,
Varney,
Yes.
Campbell,
Yes.
Gruber,
Yes.
Stegman.
Yes.
Motion carries.
and then I had a question. So for the residential, it's not being attached to the building, correct? It's just in the yard?
Correct.
Okay. And I think so in number 1, after square feet, in area, is that stricken or not stricken? It looks stricken, but I thought,
her sign is stricken.
but to be consistent with number 2, it was not stricken, and I think, well, it doesn't really matter, I guess, but, to be consistent. I didn't know if it was or was not stricken. It was very light colored compared to per side. So that's why.
I'm sorry, through the chair to Commissioner Housley, can you clarify what language you're looking at in subsection 2 that is inconsistent?
No, so in area, looks like is stricken in the, well, no, maybe it's just my print job. This one looks more clear. Never mind, sorry about that.
Per side appears to be stricken, but.
Per side is stricken, yes. in
And per
the-
side doesn't exist in item 2, I don't believe.
Yeah, no, it just, it looked struck in mine. And the last sentence in 2, I think is incomplete, or is it?
These signs may display non-commercial messages or on-premises commercial messages.
That's pretty complete.
Okay, I've got printing issues on my computer, because it looked like these signs were stricken also, okay. All right. Okay, thank you.
Any other motions? Or as I stated, there were a couple other ways of going about this one. Second thoughts? All right, seeing none. We have the adoption of the resolution as amended and recommendation.
I have one other question. For the non-conforming sign section, 2207, oh, no, never mind.
Okay,
If
call the
other
roll.
changes weren't done. I'd just like to make a comment. So I thank the commissioners for the amendments to 2201.08. I am concerned about the vagueness with the current messaging. I guess we'll have to agree to disagree. I would like to see a timing aspect or something else to better define between non-permanent and permanent. I see us right back in the same situation of what is not easily distinguishable between the two and lack clarity. So although I support the changes to the 2201.08, I'm concerned that the definitions are not clear enough, so I would not recommend this going to the city council and would be voting no.
Anybody else?
Mr. Chair, if I can just very briefly address kind of our rationale for why we didn't include a time limit. I know that a motion was made and wasn't seconded, so I don't want to belabor the point, but just want to put on the record briefly why we didn't do that. And the concern was that that would then lump in a lot of other signs that I don't think were necessarily intended to be lumped into permanent signs. The types of permanent signs that you allow under your ordinance, particularly in residential districts, is very limited. As I was driving into City Hall today, I drove down some of the residential streets just to look at some of the signs that are in the yards that if we put a temporal limit would be included. There was a suicide prevention hotline sign in somebody's yard that I'm assuming they probably keep up year-round or close to year-round. Security signs like the ADT signs or Simply Safe or Ring Camera. Small little signs, but a lot of people keep them in their yard year-round so that people know, don't try to break into this house because we've got a security camera. There was a Black Lives Matter sign, and then there were several Neighbors Need Neighbors signs. So those are some examples of the types of signs that if we put a temporal limit and said, if a sign is left up for more than 90 days or more than 180 days, it becomes a permanent sign. Those are the types of signs that would no longer be allowed under your ordinance. And that was the reason that we decided to leave that out in our proposal so that we didn't all of a sudden bring in a bunch of other signs and preclude them when that wasn't necessarily the intent from a policy perspective.
Okay. Anybody else have anything they want to say? So for me, this is a tough one because I'm going to reluctantly vote yes, but I think we're turning public property that's privately owned into the giant HOA. And you're so restrictive and overbearing on our neighbors and what they can do and what they can't do on their own property. So I think it should be looked at again at some point in time and half of this slashed.
I have a comment before you vote. So Commissioner Hosley, we just put in 2 of your amendments, and you're still going to vote no?
As I said, I appreciate the support for those amendments, but I am concerned that one reason that this was sent to Planning Commission was to have clarity on what is and is not permanent. And by the definitions, I do not see the clarity added, especially when I look at ordinances from other jurisdictions with regard to their definitions of permanent or temporary signs. Warren actually defined temporary, did not define permanent, did define portable. And I do appreciate the unintended consequences of the time limitation, and that is difficult. But with such substantial signs being defined as falling in the definition of non-permanent, it does not give a reasonable expectation of what would or would not be permanent. As I said, temporary sign with lighter weight material. Bob even had commented about, easeability of moving it is very subjective. And,
I get it. I just was making sure.
yep.
Okay, any other comments? If not, Samantha, if you please call the roll.
Hasley,
No.
Nichols,
Yes.
Polk,
Yes.
Sherman,
With all respect to the progress, not perfection, which I agree with, I'm going to vote no.
Barney,
Yes.
Campbell,
No.
Gruber,
Yes.
Heinig,
Yes.
Stegman.
Yes, motion passes. Okay. We beat number 5 to death. Hour and
And then some.
20 minutes.
That's a good sign.
All right, 6,
Haha, very good, Clark.
master plan update. Kelly?
Thank you. Thank you. As I hope you are all aware, the master plan was sent for distribution by the city council as recommended by this body. It is in the world circulating for the required 63-day period. And after that time, the planning commission needs to hold a public hearing. So we are asking that you all set a public hearing for the July 10 meeting.
Okay, thank you. Anybody wish to make that motion?
I move that we set a public hearing for the 2024 master plan for the July 10th, 2025 meeting of the Planning Commission.
Support?
It's been moved and supported. Any other discussion? Seeing none, all in favor?
Aye.
Aye.
All opposed? Okay. Public comment. Citizens in the audience may address the planning commission regarding items not on the agenda. State your name and address. You have 5 minutes.
Lisa Croupiers, 561 Indiana Avenue. Just to clarify, for future reference, there is another property managed company that, other than Beach Walk, that uses a permanently affixed sign. It's Blue Coast Properties, so it's not just one, I think, was brought up.
Same company. Actually, it's the same company.
Blue Coast Properties
Yeah,
is the
it's
same?
part of the signs, isn't it?
Its sign is completely different.
No, but I mean, we're here for talking about signs.
No, I
We're
know,
talking
but I'm
about
saying,
signs,
I'm
right?
saying that
Oh,
it came up
okay.
and for future consideration.
I apologize.
Okay, so, that's all I'll say about that. Also, for future consideration, Commissioner Campbell mentioned about names and topics included as part of the minutes when there is communication sent in. And I know, you don't have to answer this for me right now, but I always wonder about that. When you mention that communication has been received from the different individuals, and I consider that as part of the public record, but maybe it's not actually included in the minutes. But I see that that would be valuable. And I'm not sure what city council does either, but I'm sure there's much more communication through city council. But especially if it's something where there's a public hearing, I think that is valuable to have that information mentioned. And not even addresses or emails, just the topic and the general yay or nay regarding that.
That's what
So-
I do.
Yes, but that's considered as part of the public record, but is it included in the minutes? Okay, so I'm not,
The minutes record what I say.
yes.
It's in there.
I know, but then whatever Commissioner Campbell was referring to, I don't think there has to be addresses and emails, definitely not emails, but the general message of the communication that was submitted. That's it, thank you.
All right, we have no unfinished business, no new business discussion. Leaves us to commission member and staff comments. Kelly?
Thank you. I know that we've communicated a little bit about this. I wanted to mention for clarity's sake that the 241 Oak Street project, the Victoria Resort application, was not on our agenda this month, and the property owners are contemplating a conditional rezoning, which would permit them to voluntarily offer conditions to the city for consideration as a part of the rezoning application. So when we receive updated information from the applicants, we will renotice a public hearing, and the item will be back on your agenda at that time. I also wanted to say that our meeting next month will be June 5th.
Okay, thank you.
Chair,
Yeah.
may I ask a couple questions?
Sure.
For the master plan, if someone wants to submit comments, do they send them to you? Do they wait until the public hearing? What would you recommend?
They can definitely submit those to me.
Okay.
Yes.
And just, I think, in answer to the question about the official record, I believe the official record is the minutes, but includes anything written, but that is not, I mean, you could get it through FOIA, but
Right.
it's not public, but it's still official part of the minutes, I believe. Part of the record, part of the record, the official record.
Well, emailed communication to you all is not part of the public record per se, particularly if they're just topics about anything.
No, I mean, if they're submitted as part of the public hearing,
If they're
because
submitted,
the notice says submit written comments to you before 5 PM or what, by.
sure, then they would be part of the public record if they're specific to public hearing. I guess I'll look for clarification to make sure I'm answering that correctly.
Yes, that's correct, and I don't know if do you typically include comments in the agenda packet, or no? If
I
they're-
think we don't usually put them in the agenda packet.
Okay, so they would be part of the record if they are submitted for purposes of being part of the record, but to Commissioner Hosley's point, they wouldn't necessarily be accessible to the public
Right.
without a
FOIA.
FOIA request.
Yeah, right.
or-
But
Yeah.
yeah, but I think they're part of the official record, but they're not part of the minutes
Correct. They're
when they're submitted as part of a public hearing.
Just a synopsis is part of the public record. The PC log, that's
Right,
in the minutes, that's easily readable.
yes.
Otherwise, somebody sends an email to all of us, we read it, and we know it, and, because this is a business meeting,
Correct.
and we're just taking that as part of the information.
But I think legally, for public hearings, if they submit it by the time and manner required under the public notice, it becomes part of the official record if the decision were ever challenged. But they're not necessarily in the minutes, but they're part of the record. That's my understanding.
Yeah, and we'll talk about this at our next meeting. It'll be one of the new business items. And that's where we'll get into all the reams of paperwork, if we print every single communication and add it to the minutes. And we've had this discussion multiple times.
No, I'm not asking to add them to the minutes. I'm just saying that I believe they're part of the public record. And then, when the zoning ordinance for the short-term rental was passed, there had been written communications about the overlay district and amendments. So if that, and they were not addressed in the hearing process, and the city council did not want to send it back to address it. So would you prefer that the city council send the overlay district back to you, or do you want it on your list? How would you like that handled? There were some condos that do not appear to be in the overlay district, but wanted to be added to the overlay district.
We can't look at it unless they send it back, I believe.
Okay. I think the planning commission can take it up on their own, but I will let city council know to send it back. Those were the only questions for Kelly.
Any other comments? Mary?
Not to Kelly, no.
Well, I'll let you do council,
Oh, so I'll-
or commissioner comments.
Okay. So something that has routinely been brought up to city council, Chair Stegman, as your comments at the March 6th meeting. And it would be beneficial, I think, for the community to hear from you on those comments in response to the communications the city has received verbally at city council, if you're aware of them. Are you not aware of them from the look on your face?
Well, I didn't know if you were,
I'm done.
okay. Mike?
No comment.
Janice?
Yes, I don't know if some of you watch the Misha website program on housing, the American Planning Association, Michigan chapter put on. It was very good. If you get a chance, I'm sure that it's available for you to watch. They talked about the first important thing about looking at housing for your master plan or for your discussion as well, but to collect as much housing data in your community as possible, looking at the pricing of homes and the wages that individuals are being paid in your community, and what you forecast in the future that might be needed for housing, and how the land and the buildings are being changed as we speak, and the occupancy of these different buildings. The second point they made, though, was how important it was to engage the community in these discussions, and particularly go to the individuals that you're serving in your community. Sometimes we forget that. Go to the employees, the renters, the developers, different ages, the seniors, and certainly expanding your audience, because sometimes you get the same input at your meetings from the same groups of people, but make an effort to go out and speak to other groups of populations within your community to get their perspective as well. So anyhow, it was a good Zoom meeting, and if you get a chance, I think it's worth it. Thanks.
Larry?
I'd just echo what you just heard. Really important to get out and draw people in that aren't going to come to a meeting by invitation. Word of mouth. Talk to your neighbors and talk to people that you don't normally see and tell them there's a meeting that's important that they be there. You want them there to get their input because you see what we get for audience. One person doesn't represent the city as well as she has represented her interests. It's not the city. So that's all I have. I did have one more thing. Thank you for being here tonight. It was very helpful to lead us through this.
Clark?
This was the second night with the resolution process. It went easier. I think the verbiage in there helped in putting together the resolution process, and I do appreciate that. Secondly, gonna move away from the camera so I can look at her. I want to apologize to Lisa for taking up your time and talking over you. That was uncalled for. Thank you.
Janice, thank you for that. And Larry, I feel the same way. That's all I have.
Okay. Bob?
My calendar says there's a virtual meeting coming up, Missing Middle Housing on the 22nd, that I think Kelly was good enough to sign me up for, so I'm looking forward to participating in that virtual meeting, Janice, just like the one you referred to, I think, so I'm sure there'll be some good value there, and looking forward to that.
That means I get to go last.
Yes,
So,
that's what you requested.
for y'all that don't know, tonight's my very last public planning commission meeting. I am not coming back. 6 years ago, Kelly's husband asked me to be a part of this commission, and then he promptly left the city. Luckily, he gave us back Kelly, so all was well, and I have since forgiven him for that. Thank you to you, Kelly, and all of the staff for your support, because it's been a ride for 6 years. I'm leaving mostly due to personal reasons. I'm about to be the president of Rotary. So if anybody would like to join Rotary, I'm your girl, call me. Happy, I'm actually going to do an event on May 19th at Cogdal where there's wine, and I will buy you a glass of wine if you want to come be part of Rotary. But frankly, my disappointment in the lack of respect, professionalism, and representation we've had has really led to my frustration on this council. And so the members of City Council, I say to you, please respect this body. I can't sit here every Thursday, once a month, and be disrespected. I don't have it in me, and I'm too busy to take that kind of crap. So please do a better job. Mary, I sincerely hope that you will show support for that resolution we just passed, even though you don't agree with it. I'm happy to be watching the council comments to make sure you represent the other members of this as well. Special thanks to Janice and Larry and Tim and Clark for a lot of patience with a loudmouth question-asking gal, because I know I ask a lot of questions. I can't help it. I just want to understand. So I'm leaving that with you to ask the questions. And special thanks to my family for listening to me talk incessantly about planning, and to Melinda Gruber for the wine she lets me have after these meetings. So thank you.
I have a question.
Oh, no.
I'm sure on behalf of the whole commission, we'll miss you. Thanks for serving.
It's been a pleasure.
It's a thankless job.
It is totally, but it's great.
Victoria Resort. That one I found to be really interesting. And I'm not sure what year that was founded. Do you know?
1925, I'm almost certain.
1925?
I've got one book that might say 1923 and the other that might say 1924, so in the 20s.
And you've heard me speak of residential creep before, with commercial properties being gobbled up for residential development or condominium development. And I think if you look at the old plat maps, you'll find to one side it was agriculture, to another side marine commercial, a brickyard, and then other resorts. And so you have to remember, that's an existing use that's been there for 100 years. So it's tough to hear some of the negative comments towards something that's endured 100 years in this town. And with that, I also had a book I ran across called The Road to Michigan's Past by Larry Massey. And I wanted to read to you a small excerpt that I found interesting. So in 1898, local congressional flock leader, the Reverend Charles D. Brower, traced the origins of the city's resort industry to a summer about 12 years before, when Mrs. Henry M. Avery entertained friends who were so pleased with the place and people as to return another season with others. The house was enlarged, then another built to accommodate the visitors. Sniffing money in the westerly lake breezes, other South Havenites soon opened their homes to guests. Many built structures specifically to house the growing number of tourists. In the summer of 1896, some 40,000 passengers arrived in South Haven by the rail and steamship. 6 years later, South Haven claimed more than 215 resorts, hotels, and rooming houses. By 1913, an estimated 100,000 visitors would come and go each season. And the number just keeps climbing until the Depression. So, I don't know, I found that pretty interesting.
All without a zoning ordinance.
All without zoning ordinance. There was commercial,
commission, no
commercial and residential. Yep. And then other than that, I guess probably the only other comment I have, Mary, to your question, I find what you and some of the council people and one person in particular to be complete and utter dross. So with that, I'll entertain a motion to close the meeting.
Move to adjourn.
Second.
Been moved and supported. Any other discussion? Meeting's adjourned.